I got a phone call last week from someone planning to launch a new service and website in about 6 months. So they wanted to know what they would need to do to be ready to file the trademark application in 6 months when it launched. I had to correct them. You can file a trademark application based on an intent to use your brand name. And in fact, it is extremely valuable and useful and recommended to file an intent to use trademark application before the launch of a product or service, if possible. When you file an intent to use application with the U.S. Patent and Trademark Office, you get a serial number, you get a filing receipt, and you appear in the USPTO's public databases. And you already have more protections than you would have had you just remained under the radar and waited to file the trademark. So it's a very useful tool, because if this potential client had waited 6 months until the launch of their new service, during that period, they would have had very, very limited trademark protection if they had not filed with the USPTO. And if somebody had come up with a very similar name and started using it or applied to register it during that time frame of 6 months, in this example, the client might have been out of luck. They might have had to change their name. They might not have had anything available to stop somebody else from using the name during that interim time. So it's always better to file as early as possible. And I want to provide one extra bonus tip, is that when you file an intent to use application, you want to document the intent. So if there are some business plans or discussions with possible vendors or suppliers or customers that show that this is a legitimate operation that you're planning, a legitimate business idea, and tie the brand name into it, that documentation may be useful later on in the event of any dispute to show that you had a true intent to launch the name and the service or product at that time. And finally, when filing an intent to use trademark application, it is essentially always better to file earlier. The longer you wait, the more you risk. When you file an application, you will have to eventually show evidence of use with the USPTO, but you will have at least 3 years after the filing to show that evidence of use.